At Doscotch Law, we believe it is important to meet with your lawyer face-to-face. We also know that it is not always possible. We now offer Skype Service so that we can meet with our clients anytime, even after business hours. It is really the next best thing to being there. My office uses technology to better communicate, meet your needs, and value your time. The client is our #1 priority. Visit doscotchlaw.com to schedule your appointment.
It is an opportunity for you to call in and ask questions of the expert. The number to call is 698-3742. You're going to see that number on your screen throughout the evening. You can actually begin calling right now. Again, it is 698-3742, and our expert this evening is Chris Doscotch, a personal injury lawyer here in Peoria on North Knoxville.
Yes.
And welcome. Thanks for being here tonight.
Yes, thank you very much.
You have been in Peoria for 22 years, long time. And the last time we were together, we were talking about car insurance and making sure that people had adequate coverage to keep themselves protected. It's a little topic tonight. It is workers' compensation. Lots of complicated laws surrounding this topic, and when we were talking in advance, you were telling me how important it is for somebody with one of these claims to have an attorney, to kind of be an advocate and help them through this whole process, right?
Extremely important. And we were talking about some of the trends and what I've seen going on for the last 22 years, and it's harder than ever, and people need a lawyer more than they did 10 years ago, more than they did 20 years ago. This is the most difficult time I've seen in my entire career, especially in people needing help.
Really? So let's talk about some of the trends. I know we have a graphic that we can throw up with some of the trends that you see happening in workers' compensation these days. What are they?
All right, the first thing is in 2011, they changed the law, and the governor now appoints the judges.
Okay.
And they get reappointed every 3 years.
Oh, wow. Okay.
So I'm not being critical, but when you're appointed, it wouldn't matter what party you're in. You're going to be looking over your shoulder, and each governor has their own agenda, and the current governor right now is against cutting work. Every day he talks about work comp.
Okay.
We need to cut work comp. We need more changes. So obviously that's an issue. Another, in my little cheat sheet here too, is more case denials.
Okay.
Before 2011, you know, you might have 10%. I would say right now, about 25 to 30% of the cases are being, so there's a huge
Harder
change.
to win a case.
Harder to win a case. Increased litigation and costs. More cases are being fought by the insurance companies. More depositions of doctors, more experts. So I'd say the cost, my costs have doubled since 2011 on cases. Doubled, almost $40,000 a month to litigate cases. And if you don't spend the money on the case, you're, you know, and more cases are, you got to do more. So that's why having a lawyer, you can't do that on your own.
Right.
Longer appeals process. The more cases that are tried, the more cases that are denied, the more appeals. So some people could be trying a case, not getting benefits, and waiting a year and a half.
Long? Yeah, that long.
2 years.
A year and a half. That's a long time.
So lower awards for disability and loss of earnings. Access to medical care has been challenged. Work comp payments have gone down significantly.
Really?
This is proven on medical, disability. Premiums have not gone down because the insurance industry is not really regulated. More companies are writing business in Illinois. They're flooding into the state. We have all these cuts, but the businesses aren't getting the benefits of the cuts on their premium, because I pay for workers' compensation too. So there's a whole new round of legislation pending right now for changes in Springfield.
And it's just constantly changing, isn't it?
Right, and they want more changes that would be more restrictive to the workers in what they're calling the grand bargain, but they haven't had a bargain in 2 years. Personally, I think they got bigger fish to fry. Even though workers' compensation probably affects more than anyone in any area of personal injury. If you think of premiums, getting your workers back to work, healthy, quickly, getting them access to care, protecting families when they're off work so they can pay their bills.
And that's why it's so important to have an attorney to help you, weed through all of these complicated laws. And so you specialize in workers' compensation. And one thing that I want to get across, because I think people don't know, I didn't know, It doesn't cost anything for somebody to call you or come in for an appointment to talk to you about their case.
Correct. At our office, you can call in, don't have to hire us, call in, ask a question. From the very beginning, any point in your case, there's no charge to talk to someone on the phone.
Yeah.
The lawyers talk to, at my office, they talk to the people when they call in. We get back to them. If they want to come in and just want a consultation, we'll meet with them. There's no charge whatsoever. In workers' compensation, there's no fee until the end of the case. It's a state rate of 20%. And if you do not prevail in your case, you don't owe us anything. And so we put all the money up for the litigation. We put all the money up for your case. If it didn't work out, which, you know, that's not our plan.
Hopefully it will.
It will,
Yeah.
and we do very well.
Yeah.
But, you know, you have no risk. And so even if you're not sure about hiring an attorney, I always tell people,
Call and ask.
Call and ask.
Yeah.
Because if you come to me later, I would rather have given you some guidance on what to do rather than having to now come in with the problem.
Yeah.
And we might talk some more later about this, about being proactive.
Exactly. We do have, a little bit later on, we've got some tips coming up for how to be proactive in situations like this, and we're also going to be taking some questions. I think we have time for one question now before we go to a break.
Okay.
This is from Troy, and it says, what if Springfield changes the law during my case?
Okay. Well, as we're just talking about here, and that's a common question I get. In the law, if they change the law substantively, so if they say, you cannot recover for carpal tunnel anymore. It does not affect anybody's case.
That had already been started.
It's called ex post facto.
Okay.
So you can't go back and change the law. The only thing a law change can do that affects a current case is if it's procedural.
Okay.
But substantively, they cannot change a right you have. The only way that can happen is through the judiciary, but from a state law change, they can't take your rights away. So if your accident, it's not when you file, if your accident happens before the change, then
those are the laws.
Those are the laws that you go by.
That makes sense. All right, well, we are going to take a break, but we've got lots more questions to get to, so stick around.
Don't wait until a tragedy to find out your insurance coverage was not enough. Contact your local insurance agent to review your policies and determine if a serious accident happens, are you underinsured.
I'm attorney Chris Doscotch. The right insurance coverage and the right attorney can affect the outcome of your case and your life. My ability to advocate for you can be limited if you do not have enough insurance coverage.
Brought to you by the law offices of Chris Doscotch.
At Doscotch Law, we believe it is important to meet with your lawyer face-to-face. We also know that it is not always possible. We now offer Skype Service so that we can meet with our clients anytime, even after business hours. It is really the next best thing to being there. My office uses technology to better communicate, meet your needs, and value your time. The client is our #1 priority. Visit doscotchlaw.com to schedule your appointment.
Welcome back to Ask the Attorney. I am Stacy Campbell, and we are here this evening with Chris Doscotch, a Peoria attorney who specializes in workers' compensation cases. We're taking your calls. The number to call is 698-3742. So you can call now if you have a question. If you've been injured on the job and you have a question, please do call. It is called Ask the Attorney. So you are passionate about helping people, and I know this from the last time I talked with you, and I think it's great that you love to come in here and give tips to people to help them be proactive in situations like this. So we are going to get to your questions here in just a second, but I want to go through these tips, things that you say people should do if they get injured on the job.
Right, I got more cheat sheet.
Oh, that's good.
Just
we like
in
cheat
case.
sheets around here.
So
I have them right here. Do you see them?
And I put down 4 tips.
Okay.
And the first one is reporting of the initial injury is crucial. And by that, I mean either to your employer, when you give them a statement of what happened, and you fill out a report. It's your own words. So it's hard to run from that.
Yes.
And when you go to the doctor, you take an ambulance, you talk to a nurse, you talk to whoever about what happened. The judges look at that first history. How did you get hurt? What did you say caused your problem?
Okay.
And the judges hold the person to that. So your initial history about how you got injured is extremely important, probably the most important piece of evidence in a case. So that's #1.
All right.
2, A lot of people are nervous to disclose pre-existing conditions.
But they shouldn't be, right?
No, you have to disclose everything. If you don't, the judge is like, why didn't you tell the doctor that?
Exactly.
Because in Illinois, if you have an aggravation of a pre-existing condition, it's the same as having caused the condition.
Okay.
Where you get in trouble is not saying, oh, I had a back injury 3 years ago, or I'd had this problem, and then later it comes up. It makes it look like you weren't telling them everything. So you're better off just putting it right out there. That's something we can handle and deal with.
All right.
Seek treatment promptly.
Promptly, yeah.
Promptly, because if you wait, if you get hurt and then you wait 2-3 weeks, well, what happened? What were you doing those 2 or 3 weeks? So if it's not getting better after a couple days, better to be safe than sorry. Go to the doctor, at least get it documented, and then kind of see how it goes.
Okay.
And then fourth is we talked about being, proactive. And, an aggressive lawyer isn't someone who yells, or, it's somebody who's thinking ahead. What do you need to do? Like we talked about calling in before, even if you're not hiring a lawyer, if it's not an emergency and you got a question about reporting your injury, call me.
It doesn't cost to call you.
Anything.
It doesn't cost anything.
Let's get that straightened out first rather than coming in with a problem and then having to explain.
Yeah. All right. We do have questions. We have lots of questions coming in. This is from David. He says he got hurt in December. Is it too late to file a claim?
No.
But we were just talking about how you have to do it promptly, yeah.
You have to do it promptly. So that's a couple phase answer. You have 3 years to file a case on the statute of limitations and work comp generally. But you have 45 days to report the injury to your employer.
Okay.
And by doing that, that can be either orally, just telling them what happened, or in writing.
Okay.
But you have to tell your supervisor. So if you were hurt in December, and generally your employer has the information that way, then you'll be fine. You have plenty of time to report your case.
Okay, this one's from Sonia, and actually this is appropriate for today. She was walking into work and fell because of the snow. It happened before she punched in. Does she have a case?
Okay, that's got 2 parts to it.
Okay.
So I got to think about it first a little bit. The first part about punching in, if you get injured at a reasonable amount of time before and after work, walking into work, leaving work, you do not have to be on the clock.
Okay.
For snow and ice, the rule is if your employer owns the property or has some control in maintenance, they pay for it to be salted, they do that, then then it's a case. If you work in a strip mall and somebody else is responsible for parking lot maintenance and you are not told where you have to park, like park as far away as possible for the customers, then in that case it could be a little bit more tricky. So that would be something to call in, and I would need to have a little bit more information to give them a full answer on that.
Okay, and I understand we have a caller on the line. Kelly is on the line. Kelly, what is your question for Chris Doscotch?
Hi, I'm wondering if I had an accident where I hurt my back at work, and an attorney represented me, and we settled the case. It was a good case, and I went back to work, and a year from now I injured my back again. Would I have another case?
Okay, thank you, Kelly, and thanks for calling in. That's a good question. If you have a case and it's closed, and you have a new accident that aggravates the injury, or it could cause partial new injury and a partial aggravation, it would be a new case.
Okay.
So you would refile. Now, certain injuries, there's going to be credits and other issues you have to deal with, but there's no credits on off-work pay and your medical. So if your other case settled and it's closed and you have a new accident, it's treated just like a new case.
Brand new case.
Thank you very much.
This is from Sabrina. I have a permanent restriction and my employer won't take me back. I am restricted to lifting no more than 10 pounds. Don't they have to give me a job?
No, they don't. There's other laws that are in play, Americans with Disabilities Act, and whether they have to accommodate a permanent restriction. But if you can't get back to the essential functions of your job, so again, I'm speculating a little bit here, but assuming that your job essentially requires you to lift more than 10 pounds, they do not have to take you back.
Okay.
And if the employer cannot take you back within that restriction, just know though that there's other protections. So while you look for alternative work within your restrictions, as long as you're doing that in good faith workers' compensation still has to pay you. That's called maintenance and vocational rehabilitation.
Okay.
And that goes on until you get some other job that's within your physical capabilities. And if you lose out on income, let's say your job paid $20 before, and because of your restriction, they didn't take you back, you're earning 10. One of the remedies is they allow for workers' compensation to pay 2/3 of the difference because you have that impairment in earnings.
Okay. Question here from Ike. I was laid off. How long do I have to bring a case? The injury was almost 4 years ago.
Okay, we talked about the 3-year statute of limitations. There could be an exception to that rule.
Okay.
So if you were injured 4 years ago and you haven't filed yet,
You're out of luck.
you're going to be out of luck unless workers' compensation had paid some benefits within the last 2 years.
Okay.
So if a year and a half ago you got a work comp check or had a medical benefit paid, then you still may be able to file it because that adds time to the statute of limitations.
Okay.
So again, that would be something where there's no charge.
Yeah.
Call in. We'd ask those questions.
Right.
And so sometimes you can extend the statute of limitations.
See, it is so important to have an attorney. It's so complicated just sitting here talking with you about it, all of the different things that you have to think about. But you know that stuff, so that's good. All right, we are going to take another break.
Don't wait until a tragedy to find out your insurance coverage was not enough. Contact your local insurance agent to review your policies and determine if a serious accident happens, are you underinsured.
I'm attorney Chris Doscotch. The right insurance coverage and the right attorney can affect the outcome of your case and your life. My ability to advocate for you can be limited if you do not have enough insurance coverage.
Brought to you by the law offices of Chris Doscotch.
At Doscotch Law, we believe it is important to meet with your lawyer face-to-face. We also know that it is not always possible. We now offer Skype Service so that we can meet with our clients anytime, even after business hours. It is really the next best thing to being there. My office uses technology to better communicate, meet your needs, and value your time. The client is our #1 priority. Visit doscotchlaw.com to schedule your appointment.
Call now with your questions. The number is 698-3742. You see it there on the bottom of your screen. So we've talked a lot tonight about the complexity of these cases and the laws that govern them. We've talked about the importance of having an attorney to help you navigate through this whole process. We've also talked a little bit about how important it is and how you have a much better chance at a good outcome the sooner you call an attorney after you are injured. So how soon should you call an attorney if you're injured at work?
I would say if you have any type of serious injury or anything that you think could require more than a Band-Aid and just, you know, 1 day off work. But if you're going to seek active treatment, therapy, diagnostics, if you have a repetitive stress injury where your hands are going numb from carpal tunnel, and those cases are really under attack right now in the state.
Okay.
A lot of denials on repetitive trauma. It's very important that your doctor understands your job. I mean, I tell people, write down what you do. You do it, but you need to know what you're doing on your job to describe to the doctor because they're very difficult cases. So if you have a repetitive stress case, it's not an emergency.
Yeah.
I'd almost call the lawyer before I go to the doctor because how you report your injury is so important, and people don't know the law, but they're held to having to know the law.
Yeah.
So you can talk about what, you know, how you need to talk with your doctor and explain what's going on and sort that out, and it makes the case go, it makes it a lot easier. You reduce the likelihood of bad things happening to you.
And no harm in calling, because as we've said many times tonight, there's no cost to call and talk to Chris Doscotch. Here's a question from Alex. Why does it cost so much to do a doctor's deposition? Can't the doctor testify in court?
Okay. Many clients ask, well, can't the doctor be here, or why aren't they coming to court? Work comp's held in in Peoria, it's held in the IDOT Becker building.
Okay.
And there's a hearing room. You have the arbitrator, court reporter, the 2 lawyers, and then the witnesses come in. A doctor has a schedule. We don't know when it's going to go. They're not going to sit over there. I mean, it's not practical. So what lawyers do is we go to the doctor's office. There's a court reporter there. Both sides question the doctor, and then the judge reads the testimony later.
Okay.
Well, as the cost and the time for the doctors have gone up, the rates go up because they're not seeing patients, they're not doing surgery, and we can't do a case without a doctor opinion. So it's just the way it is, and the more litigation there is, the more depositions, and it's just what we got to do.
Okay. Here is another question from Randy. I deliver packages and have to get in and out of my truck, and my knee is hurting. Is this a case?
Okay, and we were talking just now about repetitive injury cases.
Yeah.
And the act of getting in and out of a truck is an everyday activity. But if you do it repetitively, so I'm thinking of like package, deliver here, the major ones in town, the heights of the step are a lot higher.
Yeah.
And you're doing that a lot more frequently than a person would in daily life. So if you have the increased frequency, the higher step, getting up and down out of the truck, I think you could make a claim, but it would be how you report it. If you just go to the doctor and say, I don't know, my knee started hurting last night, then you're explaining away. But if you go into the doctor and you're like, my knee started hurting the other night, I have this job where I'm in and out of a truck 72 times a day.
Okay.
I've been doing this for 8 years. Do you think that could have something to do with it?
Yeah.
That could help you out in your case.
Okay. This is from Mike. Says he was injured at work. Is it a cut and dry amount that you get for certain body parts, or how does that work?
Well, yeah, each body part is given a different value by the legislature.
Okay.
So they can change those, not backwards, but going forward.
Yeah.
And so a hand at 100% disability is 205 weeks, a leg's 215. This sounds ridiculous, but it's how it is. 500 weeks for a whole person.
Okay.
So if you don't have a loss of earnings from your injury, it is a percentage, but they look at your impairment rating, your age, have you lost any money? Do you have any restrictions in the nature of your injury? And all those factors get considered together, nature of your work, to come up with it. So yes, there's a range.
Yeah.
The predictability of the judges factors into it, but it's not cut and dry either. It's kind of, I'd say it's a little bit of both.
Okay. This is from Calvin. What is the time frame for appealing a case?
Okay, so I'm assuming this person probably has a case on appeal and they're waiting.
Maybe, yeah.
There is none. That's a real problem.
Time frame? Oh,
like if Springfield wants to change some laws, they could streamline the appeal process. Because if you're out there for a year and a half without pay, and you win the case, now your employer owes you a year and a half of pay, and we haven't gotten anywhere. If you don't have pay for a year and a half, how are you going to pay your bills? The case can be appealed at least to the appellate court by a matter of right, and that can take anywhere from a year and a half to 2 years if we tried your case today, and that's a long time.
All these cases take this long?
No. I mean, they don't, but if it's appealed, if the other side wants to appeal it out, or you do, you can take it out that far, and that's a lot of leverage.
Yeah.
So you want to reduce getting into that, again, being proactive so that doesn't happen.
Right. Okay, Marty has a question. I went to my orthopedic doctor's appointment, and a work comp nurse showed up and went into the appointment. Do I have to allow this?
No. They should have told them beforehand that someone was going to be there. If I'm involved in a case, I allow the case manager, or it's called a nurse case manager, we'll allow that to go on.
Okay.
But you have a right to have a private exam with your doctor, to be able to talk freely without the insurance company there.
Yeah.
So what I recommend is you talk with your doctor privately first. If they want to get information, they can come up and talk to you and the doctor together, so everybody knows what's going on. But you do not have to let them into the appointment, or you absolutely not.
Okay, well, that's good to know. Here is a question from Nell. She was injured at work, was told by an attorney it was bodily whole injury. The doc's number of surgeries, does the number of surgeries change the amount of the settlement?
Okay. Whole body, we were talking earlier about body parts. The whole person, so if you have a back injury, it's called a whole person injury. That's 500 weeks. The number of surgeries would make a difference. That's one of the 5 factors for consideration. So if you have 3 surgeries for a herniated disc, which hopefully you don't have, but that means you had complications or not an optimal outcome, the more surgeries you have, it should increase the percentage of your disability.
Okay.
As a general rule.
Okay. Chris Doscotch is your name. I know we have a graphic that gives information about where to contact you, and as we've mentioned all evening, it doesn't cost anything to call. It doesn't cost to come in and talk about your case. You're on North Knoxville. You see the numbers there up on your screen. So if you've got any questions about anything, just call, right? That's the best thing to do.
In any case, I think anything, again, whether it's personal injury even or workers' compensation, again, we don't charge to talk to anyone. And I just think it's really important now to be proactive for yourself. Because the goal is to get the proper medical care, get back to work. Because better than a settlement is having a job and working and providing.
Always,
But at the same point, injuries are a reality of it. And you want to be ahead of what's going on, and you just don't know. So if you call someone and you have some power is information is power. The more information you have, then I think you're going to reduce the likelihood of getting leveraged with your pay or controlling your medical.
Well, thanks so much for being here tonight. Did you have any final words you'd like to say? Anything?
Just say thank you for everyone out there, and hopefully the snow will be gone shortly.
Quickly, yes.
One day isn't bad.
Chris Doscotch, Ask the Attorney. Thanks so much for joining us tonight. Until next time, have a great evening.